Good morning, everyone, and welcome to Dorsey and Whitney's annual Food Summit. I'd like to introduce Bridget Hayden, co-chair of the firm's Food, Beverage, and Agribusiness Industry Group and partner and head of the Minneapolis Patent Group. Bridget?
Thank you, Rima. Today's programming has been coordinated by Rebecca Bernhard, a partner in Dorsey's employment group, and myself. Rebecca is unavailable, but she was a tremendous help in building today's panel discussions, and I want to thank her for her partnership. A few housekeeping items before we begin. The materials and CLE attendance form are available for download using the link in the reminder email sent from events@dorsey.com. We will also put links for these materials into the Zoom chat along with the CLE code for states that require that. Dorsey will apply for CLE credit in states listed in the invitation. Make sure to return your completed attendance form to attendance@dorsey.com. Unfortunately, we have a lot of ground to cover today, but if you do have questions, please contact the speakers directly or reach out to your usual Dorsey contact. Moving into our first panel, managing current and future PFAS challenges in the food, beverage, and packing industries. Our first panelist, Dr. Lisa Navarro, is a principal in the Product Stewardship and Regulatory Group at Ramble Health Sciences Consulting. She has her PhD in toxicology and has over 20 years of experience in product safety, compliance, and regulatory affairs. At Ramble, Dr. Navarro provides strategic guidance for the approval and ongoing compliance and stewardship for consumer goods such as food ingredients, food packaging, cosmetics, apparel, and agrochemical pesticides. Mark Castor is a partner in Dorsey's Regulatory Affairs Group and an active participant in Dorsey's Food, Beverage, and Agribusiness Industry Group. He obtained a master's degree in public health while attending law school. Mark's expertise is nationally recognized, and he has over 35 years of experience helping clients resolve regulatory compliance matters in litigation, administrative actions, enforcement proceedings, and complex negotiations. Kayla Weiser-Burton is an associate in Dorsey's Regulatory Affairs Group and helps clients on environmental matters such as permitting and operational compliance, regulatory enforcement, remediation, and closure. Mark, please take it away.
Thank you, Bridget. On behalf of myself, my colleague Kayla Weiser-Burton, and our special guest, Dr. Lisa Navarro from Ramble Health Services Consulting, let me also extend a welcome and good morning. A special thank you here to Dr. Navarro. I've had the great opportunity to work closely with Lisa and her colleagues at Ramble. We've had significant matters involving food products and the FDA, where we've achieved excellent results for our clients. So thank you very much, Lisa. Today's first topic is managing current and future PFAS challenges in the food, beverage, and packaging industry. So let me start with the background. Next slide there, Kayla. So what are we dealing with here? PFAS are per and polyfluoroalkyl substances. The acronym PFAS comes from that. It's a family of synthetic human-made chemicals. They're commonly used, have been used for decades, and there's literally thousands of, I think, over 12,000 varieties of PFAS chemicals. Regulators have focused on just a few, but there's a significant number of PFAS chemicals out in the marketplace. I was a water chemist before going to law school. And over the years, I've seen new chemical regulations almost every year, whether it's heavy metals or lead or arsenic, urea formaldehyde, asbestos, VOCs, acrylamide, TCE, PERC, radon. There's a new chemical du jour almost every year. And PFAS now are gaining attention both in the States and nationally. PFAS are highly stable compounds, meaning they don't break down. And people are generally exposed to PFAS through impacted drinking water, in fish and food products, in packaging, food and consumer packaging, that are treated with PFAS. And generally, it's oral and skin contact exposure with lesser exposure through the air. We've been involved in a number of court cases involving PFAS. We'll expand on that a little later in the program. There's been EPA cleanup cases. There's been groundwater contamination leading to class actions. And we expect these cases to continue to accelerate. And we expect to see more consumer product cases involving PFAS in the courts. So look for that later in the program. It's not limited just to packaging. It includes infant products, firefighting foams, textiles, cosmetics, and now, of course, food packaging, consumer products. Next slide, please. In the food and beverage packaging industries, PFAS can be found in items like pots and pans and containers, clamshells, parchment paper, butcher paper, film wraps. Really, it's ubiquitous across the board. It's in most every product or process. The causal links to human health impacts aren't precisely known. That science is still evolving. But studies have shown some potential for immune suppression, cancers, liver disease risks to infants and children. PFAS regulations have been accelerating. Everyone is on the program this morning has been involved in some PFAS issues for clients over the last couple of years, but it's been building. And the lack of harmonization among the states and no overarching federal regulations created this patchwork system of laws and regulations and policies that is making it difficult, if not impossible, to assess the risks and take steps for compliance. We're seeing a lag here between the science, between regulations, and between what companies and supply chains can practically do. Next slide, please. The states are taking a different approach, and we're going to expand upon that in a few minutes on the regulation of PFAS and what constitutes food packaging. It's all over the map. Some of the states focus on packaging made from plant fibers. Others are more broadly regulating. Some states are banning the sale, manufacture, distribution of food packaging where PFAS have been intentionally added. Other states regulate any amount of PFAS. One state has actually set up a near total ban. Next, please. So California is unique, it always has been. They're regulating PFAS and prohibiting PFAS intentionally added in products, and also limiting PFAS regardless of whether it's intentionally added or not to 100 parts per million. How is that measured? We're going to spend some time, and Dr. Navarro is going to help us understand both the science, the testing, and how we should respond to these PFAS regulations. More to the point, though, in the retail sector, customers have set up stringent certification requirements. And in some cases, PFAS are being totally banned or will be banned in the future. Dick's Sporting Goods, for example, said they're going to ban PFAS in any products they have starting in a year or two. Some national companies have said they're going to stop utilizing PFAS in manufacturing processes. So this is picking up steam. Train has definitely left the station. It's full steam ahead, if you will, in regards to how PFAS are going to be regulated and ultimately banned, I believe. So we're going to cover all of these topics during the program this morning, and we're going to provide sort of the current legal framework. We're going to discuss technical aspects and provide some recommendations for managing PFAS risks into the future. With that, I'm going to turn it over to Dr. Navarro to begin the discussion on what the FDA has done historically and where we're headed. Lisa?
Hi, good morning. Thank you, Mark. So really relevant to the food industry is the historical use of PFAS in food packaging. So the FDA has authorized at one point, close to 70 different food contact materials that were polyfluoroalkly materials, some of which have been voluntarily removed from the market, and some of which still remain in use. So it really presents an interesting dilemma as we move forward through the changing regulations with the states. We're seeing where we've got food contact materials that are still authorized for use and others that are not. And then we've got states that are taking a decision that's in opposition to the federal landscape. So it's definitely setting things up to be a difficult situation to manage. We can go on to the next slide. Here, in addition to food contact materials, this slide is also showing that there's a variety of consumer goods that are being impacted by state regulations from a varying degree, ranging from artificial turf to cosmetics to school materials. The list goes on. And so I'll let Kayla cover in detail the regulatory actions across the different states.
Thanks, Lisa. So we've pulled together this state PFAS matrix, which summarizes the various state regulations specifically related to PFAS in food packaging. So on the left-hand column here, we have those states and statutes which are explicit on the incidental presence of PFAS in the food packaging. And then on the right here, we have those states who are not and are kind of opposite and are silent on the incidental presence. On the actual rows here, the far left, we have we've broken it down by whether the statute addresses all types of packaging or whether it is limited to specific types of food packaging that are being regulated. Now, I'm not going to spend the time to go through and read the summary of each of these, but given today's audience, I do think that it's worth focusing on Minnesota in particular. And they have a regulatory regime which will be implemented beginning January 1 of next year. And it essentially, high level really comes down to providing that no person shall manufacture, sell, distribute, or offer for use a food package that contains intentionally added PFAS. And Minnesota has included a more broad definition of what is food packaging. And it is inclusive of containers applied to or providing means to market, protect, handle, deliver, serve, contain, or store a food or beverage, and includes a unit package, intermediate package, as well as shipping containers. This regulatory regime will apply to unsealed receptacles and individual assembled parts of food packaging, such as bracing and cushioning, weatherproofing, inks, and labels. Now, Minnesota's statute has defined PFAS as a class of fluorinated organic chemicals containing at least one fully fluorinated carbon atom. Violations of this statute may result in civil penalties, and the Attorney General is also empowered to seek injunctive relief or specific performance. Moving on through some of these additional ones. So as I mentioned earlier, here we have the states that are regulating plant-based packaging in particular, such as, New York, California. Continuing on, we also have Colorado and Hawaii. But I would note that, this table focuses on the current implemented regulations, and there are a handful of states that are introducing measures to prohibit PFAS in food packaging in one way or another, but they have not yet been passed into law. And kind of as a final note on this state matrix, the laws referenced herein are summary only and subject to change in state guidance. And we do recommend always checking on the status of individual state laws, regulations, and agency guidance, especially provided, the quick, rapid changing landscape here. With that, I'll turn it back to Lisa to kind of highlight some of the similarities and differences among the states.
So before you do, Lisa, let me just jump in and say that, we've seen states, in particular California, move to regulate chemicals and toxic chemicals in consumer products. Most of you are likely aware Prop 65 has been around since 1986. There have been challenges to the state laws based on preemption, based on interstate commerce. What's unique about Prop 65 is it's not a prohibition, it's a warning label law. Here, though, and for PFAS, we have complete prohibitions of products that move between the states. And so I would anticipate here, as we get into some of the enforcement discussion later, that we're going to see preemption arguments. We're going to see, challenges based on interstate commerce questions. And so it's something to keep in mind and something to watch out for. Ultimately, a lot of the PFAS related regulations and legal challenges are going to be front and center with the higher courts. So Lisa, let me turn it over to you to talk about some of the specific states.
Sure, thank you. So yes, this slide just points out a couple of states that have some unique differences in the way that they're approaching PFAS regulation in food packaging. So you'll see all 4 have defined PFAS in a similar manner, so that's helpful. However, each of these 4 states has approached the regulation in a different manner, which makes it very difficult if you're moving, goods between states. So your interstate commerce becomes a challenge. So Vermont is focused certainly on intentionally added PFAS, and their definition of food packaging is quite broad, with any packaging that is intended to be in direct contact with food. And they do offer or suggest that obtaining certificates of downstream compliance from their suppliers for adhering to these regulations is an approach that they recognize. California has a dual approach for both intentionally added and unintentionally added PFAS, with a 100 part per million limit on any PFAS that may be found. However, their approach to food packaging is really focused on materials of plant origin, similar to what Kayla was pointing out in her previous slides. Interesting with California as well, if you can go back, please. California had no grandfathering. So when their regulation went into effect at the beginning of the year, it was immediate. And so that was an interesting impact on clients and their ability to move goods and to change already made articles to use them in other states. New York has a similar approach to Vermont, although they're focused on plant-based material. And Hawaii has a different approach altogether. They had an earlier prohibition on specific types of food contact containers, with a later regulation coming into play that's more broadly similar than, similar to California and New York, where it will be paper and paperboard of plant-based origin. So thank you for that. Next slide.
So let's talk a little bit about the varying state regulations. You can go to that matrix, and we're updating that regularly, and we'll be sending out to attendees the most current and updated matrix that we've prepared. But there are 3 or 4 main aspects to the PFAS regulatory environment that really offer significant challenges to our clients. The first is regulating PFAS and defining what a PFAS is. As I said, there's over 12,000 synthetic chemicals, human-made chemicals that fall in the PFAS category. But the regulations typically look at and define broadly PFAS as a class of fluorinated organic chemicals containing at least one fully fluorinated carbon atom. Lisa can give us some more details on that a little later in the program about what that actually means, but we aren't just regulating one particular chemical like TCE or lead or PERC. This is a whole class of chemicals, and it presents a lot of challenges, both in testing and obviously ultimately in compliance. Same holds true for food packaging. What is food packaging? We have sort of our intuitive understanding of what that is, but the states have, in some cases, made it quite broad. Some states limit it to plant-based fibers in packaging products. Others are across the board, whatever kind of packaging. It could be clamshells, it could be anything, non-fiber based. Really, what it boils down to is it's containers that provide a means of marketing or protecting or handling a product. It includes unsealed receptacles. It includes utensils and products like cups and plates and bowls, foil trays, wrappers. I mean, the list is very broad. And in particular, it can cover individual component parts, like the blocking and bracing and cushioning. weatherproofing, and all of it, adhesives and inks and labels. Some states do have exclusions for non-primary packaging materials. Others don't. So I think, when you're looking at how should my company comply, you have to be looking at a broader range of what's included. And you have to be looking at your dyes and your pigments and your adhesives and your stabilizers, because these are all potential inputs to PFAS into your process and into your products. Next slide. So we heard many of the state regulations talk about intentionally added. And what does that mean? I'd like to say that there's a good understanding or complete understanding of what intentionally means, but we don't have that luxury. In many aspects, it's the deliberate utilization of PFAS chemicals. And some states make this distinction between intentionally added versus incidental presence. Other states don't. And so I think you really have to look at each of the states, and a lot of our clients are trying to manage this to the lowest common denominator, meaning they're looking to comply with the most stringent state regulation. But that's changing. We've got 12 states right now that are regulating PFAS in some way, or will be in the near future. But what about the remainder of the states, and how will new regulatory programs impact expensive decisions that companies are going to make? So I think, this is all evolving, and we understand that it makes it very difficult for companies to try to come into compliance. And we're going to give you some suggestions and recommendations near the end of the program to try to help manage PFAS going forward. Next slide. So, and Lisa, jump in here, but what about PFAS that are used as processing aids? So this is not the direct impact. This is not, in the carton or in the water, in the food. It could be in the water, I guess. But Lisa, give us some thoughts on, the use of PFAS as processing aids.
Yeah, absolutely. So a recent example, I had the privilege of discussing PFAS as processing aids with a polymer chemist who shared that a common use is as a release agent. And so, for example, like making polypropylene bottles or containers, they will, if the shape is very unique, in order to get it to release from the equipment, they will run PFAS through the equipment lines so that it serves as a lubrication. And so while PFAS is not directly added to the packaging material, its use as a processing aid in this capacity does end up delivering some residue of PFAS to the product. And so that's a classic use as a processing aid. Certainly, there's other unintentional sources to consider as well. There's a recent publication that was released last month showing that at least 45% of the drinking water samples collected across the United States had at least one type of PFAS in them. And then if you take a look at what's happening in Maine with the agricultural industry and the animal husbandry, we've seen a lot of activity, farmers not being able to use their dairy products because the cows had PFAS in them. And a lot of other, regulatory developments around measuring PFAS in food matrices. So the AOAC has just proposed a method for measuring about 30 congeners of PFAS in about 8 different food matrices. So this is in development and coming, but it's certainly, unintentional sources, really need to be on your radar, as well as the intentional sources.
And what about post-consumer recycled materials? I find this to be one of the biggest tensions that we're going to have going forward. For years, of course, we've wanted folks to recycle. We want to use post-consumer recycled materials and utilize those as opposed to having them go into landfills. But post-consumer recycled materials are going to be full of PFAS. Some states have excluded PFAS from post-consumer recycled materials to, again, continue to promote the use. Others have been silent or haven't included any kind of exclusion. So I think this is going to be the source of ongoing tension between those that want to push recycling and recycling programs around the country, and cleanups of landfills, versus, the sort of consumer protection side, which is, the use of these materials which contain PFAS, and are exposing folks to increased concentrations of PFAS. So look for more on that tension between recycling and PFAS and post-consumer materials. Next slide, please. So how are companies managing PFAS laws? Some of the laws actually require certificates of compliance. And a certificate of compliance is simply a document affirming that products and components of the products meet legal requirements, meaning they don't have PFAS intentionally added, or in some cases, there's no PFAS above certain limits. The requirements for COCs or certificates of compliance vary among the states, and there's no harmonization. Some states apply the requirement only to manufacturers. Other states require you to look up and down the supply chain and distribution chain and make sure that, PFAS are out of that chain. What we're seeing as a trend for our clients is that their customers are asking vendors to provide broad certifications for themselves and, in many cases, for the suppliers of raw materials, so that it's sort of complete supply chain evaluation. It makes it very difficult to sign a certificate of compliance. New York, we'll talk about this a little bit more later, allows companies who obtain a certificate of compliance to rely on those to help mitigate or manage the risk and avoid enforcement actions. But a lot of states do not have that kind of reliance provision. So the requirements depend on location, and in some cases, you're required to provide COCs to the state on request. In some cases, your customers are going to require you to sign, and it's not a level playing field. We see changes obviously among the various states, but also among where companies are situated in the market. Some companies will sign anything. Others are looking at this in a very prudent way and taking steps to make sure that their raw materials are in compliance, because they want that reliance defense. Most companies are looking at maintaining files and providing to purchasers on request these certificates of compliance.
A difficult thing with the certificates of compliance is certainly the folks that are completing these at the different companies that you may be sourcing from may not understand all of the sources of PFAS. And so they may unintentionally sign a certificate, not realizing that there could be unintentionally added PFAS from water or from plant matrix or from equipment use.
Next slide there. So here, the next two slides include some actual examples of certificates of compliance. And the point here is to just demonstrate how broad some of your customers are asking for certification. For example, this one requires suppliers, vendors to certify that they're not offering for sale or distribution any food packaging containing intentionally added PFAS. And then defining what that means in terms of what kind of packaging and where it comes from. Others are, including certifications that they comply with California's 100 part per million. And we're going to talk a little later about how do you even test for that and what does that look like. Next slide, Kayla. Other customers are asking that not only do you supply a certificate of compliance for the products you sell, but also that you go to your raw material suppliers and obtain certifications or affirmations from them that their products are in compliance. It makes it very, very difficult to to try to ascertain and ultimately comply with these requests. Next. Kayla, I'm going to toss it over to you there to talk about some of the enforcement issues.
Yeah, so kind of in a similar vein as we've been talking, with all the variety among state regulations, the penalties for non-compliance also vary quite a bit. In some cases, you're looking at civil penalties of up to $10,000 and criminal penalties of up to $50,000. Civil penalties, for instance, in Minnesota, as we discussed earlier, are also a little bit higher of, $20,000 per incident. And again, as Minnesota kind of presents, some laws will also allow for injunctive relief. Now, it's possible that some states will regulate on an each package type of basis, and we do expect it is, quite likely with this kind of changing landscape that we could see product recalls for products with packaging that don't necessarily comply with these statutes as they're, rolled out and as they're updated and as continuing agency guidance is released. At the bottom here, we note that there are, just the different compliance deadlines between the states. And in certain cases, there are kind of rolling deadlines, smaller groups of packaging, subject to regulation, and then that broadens over time. So again, it's imperative to really be on top of kind of the state regulation and what is current and, active and being regulated today.
So, okay, let's go back one slide just to add to that. I think we are going to see and have seen product recalls, both voluntary and there may be mandatory recalls. The FDA under the FSMA statute has the ability to mandate recalls. So we're going to see more and more regulatory controls. And as Kayla was saying, some of the civil penalties can be on a per violation basis. Well, if you put thousands or millions of products into the marketplace, obviously the potential enforcement issue here is very significant from a penalty perspective. We're not quite sure how the states are going to enforce, but like in Minnesota, which its law is coming here in 3 months, we're going to have a state agency and the Attorney General's office that will have broad powers to seek not only penalties, but also seek injunctive relief. Some states have already started regulating. You can see that New York and California are out there regulating. Others are going to be coming online. I want to contrast this to, how Europe is regulating. They've done a glide path program where, PFAS are going to be regulated over the next 12, 13 years. And Lisa's going to speak a little bit more to that. A number of states, Maine, for example, had a complete prohibition in place, and they repealed that and moved to more of a notification requirement with prohibition starting in 2025 and full prohibition in 2030. Whether states are going to follow the lead and try to, put forward a more practical implementation is unknown. There's a lot of push and pull here, but I think we're gonna see some significant enforcement actions here, both at the public level and then obviously private litigation and perhaps class action litigation or continued class action litigation involving PFAS.
So now I think we're going to move into some of the more technical aspects of the PFAS laws, and I'll turn it over to Dr. Navarro. Take it away.
Thanks. Yeah. So how did we get here? In 1998, the EPA was first notified of PFAS as an environmental contaminant. And since 1999, the CDC has been measuring for a small group of PFAS chemistries in the participants that are routinely part of the NHANES surveys. I think to date, they analyzed for about 400 different chemistries. And PFAS chemicals have been detected in 97% of samples collected. And samples have been collected from every state across the country. So it's definitely a widespread exposure paradigm that really still leads us a difficult kind of understanding of the human health effects. So we know there are animal studies, and we know there is some data coming out suggesting, a variety of potential human health effects, but really trying to find that direct link is difficult. And some of the difficulties associated with the vast variety of chemistries. So we're not looking at a single substance cause and effect. We're looking at a family of up to 14,000 different chemistries that each have their own health impact trajectory. It makes it very difficult for the agencies to really understand, where things stand from a human health perspective. Next slide.
Lisa, before we go, how does NHANES, how is that utilized, and what impact does that have in terms of agency decision making?
Well, the NHANES data has a lot of different uses, but certainly it's been used to understand the kind of the exposure paradigm across the country, as well as data is funneled into agencies like the EPA and the FDA for setting different health standards. So we've seen, for example, the drinking water standards, the numbers going down. But I believe the current target now is 0, which will be an interesting target to try to achieve. And then it's also supports funding that's being, put together to help the agencies design, multi-component complex mixture studies for human health effects evaluation.
So I can say we've used NHANES data, and it can be both a sword and a shield. It can be used from a data set perspective to validate a risk, but also to invalidate a risk. I worked with Lisa and others at Rambo not too long ago to use NHANES data to support a position we were taking with the FDA that there was no risk, and we were successful in that. So it's a significant database of information, one that doesn't get a lot of high profile, but it's something to think about when you're looking at the defense of claims relating to PFAS and a host of other chemicals in food products. So, keep that in mind as we progress the discussion here. What's the next slide?
On the next slide. So we talked a little bit about the analytical challenges earlier on. I think the most interesting is the approach that California has taken, and that's this 100 part per million measured as total organic fluorine. And so this is exactly what it says, just total organic fluorine. It does not distinguish between allowed and not allowed food contact substances, for example. There are no specifics on the analytical methods in terms of, there are other uses for fluorine. So it's really frustrating to have this regulation set with a TOF threshold. And then it begs the question, without sufficiently specific and enforceable analytical methods, what will happen with all the other food contact fluoropolymers that are still on the allowed list? And then, it takes you further into really thinking about the impact between intentionally added and unintentionally added, and how that even, what really is intentionally added. If you've used recycled materials and there's a risk of PFAS, is that an intentional use? If you're using municipal water that you've seen a report that PFAS is there, is that an intentional use? So I think, as we move through the regulatory and legal landscape across the states, and really understanding, what's happening from one state to the next and what it means from a scientific perspective. This is not the first time that government or state government has gotten in front of the science. And so right now, the regulations are being promulgated in advance of the technical capabilities of the science. I mentioned earlier, so the Association of Official Analytical Chemists, the AOAC, they've just worked on a method. They can analyze less than 50 congeners of PFAS out of a family of 14,000. And that's just a proposed methodology. There are some other methods that are also in development, but there are not sufficiently specific analytical methods out there. Yet we've got all of this regulation that's already down the path, making it a very challenging environment for understanding kind of what to do and what do you have in your product, and can you do the forensics on where it came from. So I'll leave those thoughts with you. We can go on to the next slide.
So Lisa, is there a background level that can be used as a baseline, or is that just across, varies across the board?
What do you mean by a background, like the environmental
Sure.
amount?
Yeah.
I'm not aware of a background level of PFAS. It's a synthetic compound, so there is no natural background level. There are different cleanup target thresholds from an environmental perspective. So historically, we've seen 70 parts per trillion as a cleanup target for ground contamination. We do see the new proposals coming from the EPA for water. But I'm not aware of an acceptable background threshold.
So great. I mean, we have the 100 part per million California trigger. And I don't know if that's going to get adopted across the board in the states or at the federal government level or at the FDA level. But if we take our lead from California, and in many respects, they're out in front on regulating chemicals and consumer products, the 100 parts per million may become that floor. We'll see. The next slide.
So this is some screenshots from the FDA's Food Contact Substances Notification Database. What is interesting here is back a year ago in January of 2022, the FDA proposed a rule where they authorized themselves to be able to amend their regulations in the absence of any human health adverse effects. And so what they are doing is they gave themselves the authority to regulate on persistence and bioaccumulation, but not on toxicity, which is historically the FDA would only make a move to remove something from the food contact substances database if there was an adverse health concern. However, in about the mid 2015, 2016 time range, several companies voluntarily ceased the use of a set of about 22 different food contact substances that were in this family of the kind of like the first phase of fluoropolymers. However, if you flip to the next slide, we still have about 50 some different fluorinated materials that are available for use as food contact substances. Now, if you were using the California method for analysis, these chemistries, just because they contain a fluorine in them, would potentially trigger this 100 part per million threshold if they were present in high enough concentration. But these are legally recognized substances that are available for continued use. At least they are right now. So it'll be interesting to see what trajectory the FDA takes on these substances as we look, reflect back to what happened in 2002 when the EPA halted the first family of PFAS materials. About 75 were the initial cluster that was subject to a SNR and removed from the marketplace, which led to the original food contact substances being voluntarily removed from the listing. So it's definitely an interesting time right now to understand how this is all going to play out for what's allowed and what's not allowed, and analytical method development so that we can find lanes where things can be used. And reflecting on what's going on in Europe, so this timeline that they've kind of set where there's like 13 years and they're giving different industries different timelines, but they're also have this kind of mindset of allowing critical uses. And so there's certainly going to be this debate over, what is a critical use for PFAS compounds. So if you were in the medical device manufacturing arena, you just can't take PFAS out of your medical device. These devices and their formulas take years and years to get approvals, not only in the US, but worldwide. And so finding alternatives has not only a scientific challenge, but also regulatory challenges. And some of the clients I've talked to, either in the personal care space or in the medical device space, they don't have technologies. I mean, if they start today, they don't even think they'll be able to meet the 13-year timeframe to find alternative chemistries. So this is going to be a really interesting challenge for, the chemical industry to come up with safer alternatives, and then for all the associated consumer good industries to find pathways to either reduce the use of some of these fluorinated chemistries, or in other cases have to completely stop their use altogether, which is what we're seeing certainly for paper and paperboard packaging. We can go on to the next slide.
So I think the key here and the takeaways are, as Lisa was saying, it's difficult. Management of change in the food industry is not something you just flip a switch on. If you're going to remove, process or materials, raw materials, or even processing aids from your operation, you need to manage that change and understand what the risks are. And so the compliance risks here, the takeaway is that because it's multifaceted, and because there's no harmonization of the laws, it makes a very difficult challenge for companies. Compliance in Minnesota, Colorado is different and doesn't mean that you're in compliance with California. So this patchwork proves to be very difficult for companies who are, trying to meet the law, and it's forcing companies to try to, focus on the lowest common denominator, the most stringent laws, which ultimately is a complete ban on PFAS, whether or not it's intentionally added in the product. The risk is compounded by the fact that there's already PFAS as a background level in the water, in the environment, depending on where you live. So food companies are going to have to add to their food defense plan the control of PFAS chemicals throughout the supply chain. It's just going to have to be incorporated into your process and your control chain. Some of the states, Washington and Maine, as an example, have said to their agencies, look, you got to help find safer alternatives. That work is underway. Washington's done some work, Maine's done some work on that. But we expect that there's going to be more disclosure laws that require the reporting of PFAS in chemicals, much like what we saw in California with Prop 65. It's not yet, known whether we're going to need to have some kind of, warning on products, but nobody wants to warn or put a label on their product that says the product causes cancer or reproductive toxicity. And we've been fighting that fight under Prop 65 for almost 30 years. And so, I think the finding safer alternative route is really going to get pushed. And it's going to get pushed on a variety of sides, both at the regulatory side, but also from the marketplace. So we're already seeing restaurants and grocery stores and retail stores and the big boxes moving to eliminate PFAS and to require certificates of compliance and threatening to take products off the shelf. We're also going to see, and Kayla's going to talk about some of the recent litigation, but we're going to see AG suing PFAS manufacturers. They've already started on firefighting foams and on water contamination, but that's going to, migrate. Sorry for the pun there, but it's going to move to consumer products and to packaging. So the future compliance risks are very significant. We've seen the potential fines and penalties, the potential for product recalls. And so this is something that's captured the hearts and minds of all of our clients. who are putting products out in the marketplace, trying to figure out how can we manage the risk, and how can we move forward. Let's go on to the next slide, Kayla, and give us some thoughts on the courts.
Yeah. So as Mark kind of alluded to there, we've been seeing a growing trend of litigation regarding the presence of PFAS in food products and packaging. And we continue this trend, or we expect to see this trend continue to grow. PFAS liabilities across the spectrum of statutory and regulatory programs and tort claims are estimated to be in the billions of dollars. And I have highlighted a few of the more recent cases here that, in particular, focus on food packaging and kind of the claims of really false advertising due to the presence of PFAS. So in this first case here, Hussein versus Burger King Corporation, it's a class action lawsuit where we have, the plaintiffs alleging that Burger King misled its customers by using safe and sustainable representations on the Whopper packaging, whereas the plaintiffs had an independent third-party study done, which concluded that the packaging contained approximately 250 parts per million of total organic fluorine. But again, to Lisa's point, it's the total fluorine versus identifying a particular PFAS, a particular PFAS in there. But measuring for the total organic fluorine is kind of a common thing that we see in these independent studies. A similar case here was filed against McDonald's Corporation, and they, in that case, the class plaintiffs alleged that the Big Mac packaging contained high levels of PFAS, despite McDonald's advertisements that their food products were also safe and sustainable. In this third case here, Toribio versus the Kraft Heinz Company, again, another class action lawsuit where the plaintiffs are alleging false and deceptive advertising on the strawberry kiwi Capri Sun juice. The product label listed specifically that it was all natural ingredients contained in the product, but the independent, third-party study, again, identified PFAS contamination of the product itself. And then finally, we have here Lorenz versus the Coca-Cola Company. And this class action lawsuit specifically related to the Simply Tropical juice, which again, kind of circling back, I know it's repetitive, but it was labeled too as all natural. But the third-party testing indicated levels of PFAS found within the product itself. I will note that in each of these cases, the injury alleged was not actually a physical harm, because that is something, again, that Lisa had kind of mentioned. It's very difficult to prove a specific injury from a specific, instance of exposure from a product which contains PFAS. So the injury in each of these cases was an economic harm in that the class members had purchased, paid a premium, or otherwise had paid more for their products than they otherwise would have absent these companies' misrepresentations and or omissions as far as the product labeling goes. So with that, I'm going to turn it over to Mark to kick us off on some of the recommendations for how to manage this landscape.
So I think what we learned through, this last 45 minutes is PFAS regulation is going to continue to expand and grow throughout the states. If you manufacture food or food packaging, you're just going to be required from a risk management perspective to evaluate your products and your raw materials and inputs for PFAS, intentionally added or present in any amount. There will be some pushback, as we discussed. Maybe going into the future, we'll have some kind of preemption or some federal overlay. Certainly, the EPA is looking at that from an environmental perspective. I expect that FDA is going to look at that as well. But that sort of regulatory framework is subject to all of the inertia that you typically see from, federal regulations or federal regulatory programs. I think we mentioned the slide up front. Congress took a look at PFAS and national regulations, and they couldn't come to any kind of a resolution, and that thing died in committee. Um, so you're going to need to discuss with your suppliers and with your vendors, the presence of PFAS in the products and in the raw materials. You're also going to need to look at your equipment and the use of PFAS as a processing aid. It may be that you'll have to look at the water inputs and other chemical inputs into your process and screen for PFAS. It's a very difficult dilemma, obviously, because the testing is very difficult to nail down. More and more companies we're seeing are being asked for requesting certificates of compliance to address PFAS. As I mentioned before, some companies will sign anything because they need business. Others are taking a more active role in trying to assess their process. But as I said, management of change in the food industry and through your food defense plans, really takes some time and presents all kinds of challenges. You can't simply change a process and change the standards without potentially impacting product health and safety. We may see more states like New York have legislation that provides safe harbors for certificates of compliance. That's an unknown. And that's why we said in one of the earlier slides to really keep tracking the laws as they're evolving. They're changing. Even states that have current PFAS regulations may change. There may be guidance and policies coming out in the various states. So it's important to take a look at that. And as I said, we'll be forwarding on an update to our internal PFAS matrix that you can take a look at. But it's going to be really essential and critical to keep following the laws and keep on top of how they're changing. They're rapidly evolving. It really is difficult to forecast that future. But I think it's time to ask and plan for alternative packaging options. There's going to be a tremendous amount of work and opportunity for alternatives. It's going to really upset the current packaging industry, I think, as companies look at alternatives. Lisa and Kayla, further to add on that?
I think you covered it really well, Mark. It's definitely going to be a challenge with finding alternatives for all of the solutions, not just the food packaging solutions, and then understanding the channels, all of the channels. So the water, the plant material, the packaging, the gaskets, the lubrication on equipment. So all the different channels that could potentially be sources of PFAS. And then, as the analytical methods evolve, understanding that if you do end up finding PFAS somewhere, how do you do that forensics to figure out where did it come from? Because different categories of PFAS will have different utilities. And so over time, hopefully we'll have, more tools on hand to be able to help us, solve, these challenges.
Kayla, where do you think we're headed on the litigation front? Do you foresee significant additional litigation? I mean, you highlighted some of the marketing aspects. Do you think we'll see some, particular exposure claims, mass tort type claims? We certainly are seeing some of that already on the environmental side with water contamination. Where do you see that on the consumer side?
Yeah, I think that it's going to follow a similar path, and we are going to see more mass tort litigation arising, especially as the regulations become more refined and further, expanded between states as well, and also as the science continues to grow on this and continues to be able to detect PFAS and potentially also help to establish that causal link. I do think that it's going to expand more out of, away from simply the advertising piece into actual direct harm. Once there's a little bit more science to be able to back that up and actually be able to present a case.
And Lisa, how are you seeing customers, or your clients asking you for help? Where are you inputting into the process here as we try to manage these legal and technical risks.
So certainly, so from Ramble as a whole, we have a very large environmental practice, and so there's been a lot of history with helping clients with their environmental situations with PFAS. If we look at it from the health sciences group, specific to product safety and product stewardship, partnering with clients to understand where. So on this kind of certificate of compliance, like where is the PFAS? How might it be in our products is one element. And then another factor is clients trying to understand where they can go to partner with technologies to find new solutions. So I look at all the different uses. It's certainly mind-boggling to realize that PFAS has been so widely used across so many different industries for so many different functionalities, and then trying to find ways to understand that impact is where we're really starting now. Is where is it? And then the next phases will be those journeys on what are the alternatives, and are they safer? And then how do you make those justifications to transition to new chemistries? And then partnering with technical product development folks that can help sort out what actually works. What other chemistries are there that will deliver the grease and water resistance, the anti-friction behavior, the release agent behavior, the water repellency behavior. I mean, the list of desirable features is very long and will be an interesting challenge to solve.
Well, that concludes our first panel. I want to thank you, Lisa, for participating, and Kayla, great job. And obviously, if there are questions, please reach out. And with that, I'm going to turn it back to Bridget and our moderators for the next programs. Thank you so much.
Hi, we're going to be taking a break and we will resume our second session at 10:15 a.m. Look forward to getting back.
Okay, thank you everybody for attending Dorsey's annual food summit. Just a reminder to return your completed attendance form to attendance@dorsey.com. After today's program, we will send out a survey and we'd appreciate your feedback. For our second panel, Insolvency Issues in the Food, Beverage, and Agribusiness Industry, Protecting Your Interests in an Uncertain Economy, we have three fantastic panelists from Dorsey. Monica Clark is a partner in Dorsey's Finance and Restructuring Group and is a co-chair of the Bankruptcy Practice Group. She regularly represents financial institutions, creditors, unsecured creditors committees, and equipment lessors in local and national bankruptcy cases. Her practice also includes bankruptcy appellate representation. Rachel Stoian is an associate in Dorsey's Finance and Restructuring Group and assists clients in financial restructuring both in and out of court. Megan Baker is a senior attorney in Dorsey's Finance and Restructuring Group and assists banks, creditors, receivers, and bankruptcy trustees in recovering and liquidating assets. Megan, please take it from here.
Thank you, Bridget, and thank you all for joining us today. Bankruptcy is something that no one wants to hear, but food and beverage bankruptcies are on the rise and in all sectors for a variety of reasons. Newer startup companies are experiencing an inability to obtain new investors or financing due to inflation and the interest rates. COVID-19 impacted many of the restaurants and food industry, especially via places that were in downtown business hubs, and employees are now working from home or not visiting as much. As well as supply chain issues. In 2023, there have been a number of food-related bankruptcy, including Tattooed Chef, which prepared or sold plant-based prepared foods, Do Good Foods, which was an upcycling company, companies that are more on the agricultural side, such as Arrow Farms and App Harvest, and then a number of restaurant chains and franchises have also filed. Entities that owned a number of Burger King franchises, a number of Hardee's restaurants, as well as Corner Bakery. It's almost guaranteed, if you haven't yet, you will at some point experience bankruptcy. Hopefully not for yourself, but either a customer, a supplier, perhaps a franchisee, depending on your business. And it's extremely important to make sure that when you learn of a bankruptcy, that you act quickly. We are going to give you a broad overview of bankruptcy issues and steps you need to take upon learning of a bankruptcy. Rachel Stoyan is going to focus on things that happen prior to the bankruptcy, things like preference actions, filing your claim once they file for bankruptcy, and some standards that apply specifically to the agricultural and food type businesses. Monica Clark is going to address what happens after bankruptcy. What happens if you have a supplier or a customer that owes a lot of money and still wants you to supply to them. Hopefully, we will give you an overview of what to do and not to do as a bankruptcy progresses. Rachel, if you want to go ahead and start.
Thanks, Megan. And thanks to everyone for joining us here today. No promises on being fully comprehensive of everything involved in bankruptcy. That would keep you guys here for years, which I don't think anyone wants on this Monday morning. All right, so bankruptcy is often referred to as a fishbowl. So a debtor goes in and is under a spotlight. Their financial affairs are open for the world to see. There's close look at what's happening to the debtor financially on a go-forward basis, but there's also a look back to the debtor's financial affairs and transactions leading up to the bankruptcy. That look is often keyed into whether there are any transfers or transactions that took place prior to a bankruptcy that can be unwound or avoided to bring money back into the bankruptcy estate being the pool of money and assets that are used to pay creditors. But on the flip side, there's also looking to whether there is any property or assets being held by a debtor really in just holding it for someone else. It's trust assets, things that actually belong to third parties and need to be taken out of the bankruptcy estate. So I'm going to kind of look at the two flip sides of that. And with that, we'll go to the next slide and we'll look at preferences. What are they? So if you are lucky enough to not know what a preference or a preferential transfer is, that's great. For some of you, it might bring back bad memories of having been hit with a preference demand. What it is are transfers or payments by a debtor in satisfaction of perfectly legitimate debts in the lead up to a bankruptcy filing that ultimately result in the recipient receiving more than similarly situated creditors. So the bankruptcy code allows the avoidance or clawing back of these transfers. So the recipient has to give back the money it was paid, and in return, it gets a claim in the bankruptcy estate or against the bankruptcy estate. These actions are generally brought in the context of, say, a Chapter 11. Management stays in control. They are the debtor in possession. So they would have an obligation to pursue actions like this for the benefit of their creditors. Often in Chapter 11 cases, though, a plan of reorganization will, one of the aspects of it will be the creation of a liquidating trust or something to that effect, where avoidance claims like preference actions become part of the res of that trust. A liquidating trustee is appointed, and their main focus is bringing these types of avoidance actions, bringing money into the estate. So that's often who you're dealing with is a liquidating trustee if it's a larger Chapter 11 case. But suits can be brought by a debtor in possession. If it's a Chapter 7 liquidation, it'll be Chapter 7 trustee. So that's who you're dealing with on the other side. Folks trying to bring money back in for money that was paid to you as a creditor on account of legitimate debts. So what's the point in that? If you were paid on account of a valid debt, why could it be taken back? The goal with preference avoidance is to promote the fundamental bankruptcy policy of equality of distribution among creditors. So you want similarly situated creditors to come into bankruptcy on equal footing. So avoiding preferences rectifies a situation where a debtor might have been favoring certain creditors over others in the lead up to bankruptcy, realized it didn't have enough money to pay everyone, so paid his best friend, but not the guy down the street. We want to avoid that. It also helps avoid where some creditors can get really aggressive. They see the writing on the wall, a debtor's not doing well, so they'll take actions to better their own position at the expense of their fellow creditors. So preference actions are really aimed at evening the playing field. But in practice, they can be seen as a stick up or a hold up for some cash, which is unfortunate, but that's the world we live in bankruptcy. So if we move to the next slide, we'll get into the elements of a preference. So under Bankruptcy Code Section 547B, it outlines 5 elements of a preferential transfer, each of which has to be established by the party seeking to avoid the transfer. They bear the burden on each of these elements. So a transfer has to be to or for the benefit of a creditor and made on account of an antecedent debt owed by the debtor at the time of the transfer. So if it's a prepayment, it wouldn't be a preference. But if it's a payment for goods that were already supplied, then a preference could potentially lie. Has to be made while the debtor was insolvent. Keep in mind, there is a presumption of insolvency under the Bankruptcy Code for the 90 days leading up to a bankruptcy filing. Obviously, that can be rebutted, but it's an insolvency analysis is a tough one to fight. The timing of the payment. It has to be made within 90 days of a bankruptcy filing, or if it's between 90 days and 1 year and the transfer was to an insider of a debtor. So an affiliate company, an officer, director. Again, we're trying to avoid debtors preferring certain folks, particularly insiders, over everyone else. So that 1 year look back is pretty tough if, say, you are an officer and you had a loan from the company, or the company rather, you loaned the money to a debtor and you saw things weren't looking good. So you're like, let me get myself repaid here. That's not a good look in the lead up to a bankruptcy filing because you're preferring yourself over other creditors. All right. And finally, what's the ultimate result? It must have enabled the creditor to receive more than they would have had the transfer not been made and the debtor went into a Chapter 7 liquidation. So if you receive payment in full, and if there was a Chapter 7 liquidation and creditors are only getting 2 cents on the dollar, that's a problem. So that element would be satisfied in that situation. And that one's not super tough in most instances to prove, because often in bankruptcy, creditors are not getting paid in full. So if you were, that's a potential problem. All right, we'll move to the next slide. So what are the limits for these preference actions? And there are a number of them. There's a lot of statutory limits on what actions can be brought and where. There is a monetary minimum. So for a creditor to be subject to a preference action, the aggregate transfers to that creditor have to be at least $7,575. That dollar amount, along with all other dollar amounts in the bankruptcy code, increases every 3 years. It's built into the code that all of those figures tick up every 3 years. So that's the current amount. And there is also a jurisdictional limit. And it's currently $27,750. So if the aggregate amount of the transfers is less than that amount, the party seeking to avoid the transfers would have to bring lawsuit in the district in which the recipient resides. And this is important because a lot of bankruptcy cases, particularly the big Chapter 11s, there's a few favored districts. There's Delaware, there's Houston, Texas, Manhattan. Those are some of your hot spots for bankruptcy, but businesses operate across the country and globally. And if you've got a small amount of transfers that are trying to be avoided, you don't want to get dragged into court across the country, because ordinarily a preference suit will be brought in the same court where a bankruptcy is pending. And so this statute is aimed at helping out little guys who may have received preferences be able to litigate in a home court instead of having to get local counsel going across the country. That amount used to be much lower. It was about half that amount until the Small Bankruptcy Reorganization Act, which went into effect in early 2020, just before the pandemic. And that just about doubles the jurisdictional limit. Just a way to sort of help out folks who are subject to these lawsuits. Another change that happened with that particular legislation was adding a due diligence requirement. So now trustees or whoever's pursuing a preference action has to establish reasonable due diligence under the circumstances into reasonably knowable affirmative defenses. It's a slightly wishy-washy standard that got thrown on there with the hope, I assume, of cutting down on just a scattershot hit every woman with a preference litigation. Because in these cases, large Chapter 11s, if you're operating in the ordinary course, you're paying your debts as they come due, that list of folks that receive payments within 90 days of bankruptcy is going to be huge. But a lot of them are going to have viable defenses. So it puts a little bit of the onus on the parties seeking to avoid transfers to at least look into it. Are there any viable defenses? Send out a demand letter, vet those before starting a lawsuit. Some additional statutory limits on the next slide. We have reclamation rights, which exist under both state law and under the bankruptcy code. So sections 546C and D of the bankruptcy code provide that the right to avoid preferential transfers is subject to reclamation rights of a seller of goods, producer of grain sold to a grain storage facility, or U.S. fishermen who caught and sold fish to a fish processing facility owned or operated by a debtor. Essentially, if one of the folks listed there, seller of goods, producer of grain, fisherman, exercises their reclamation rights in that 90-day preference period, this provision says that it can't be avoided as a preference. There's a bit of a split in the courts of whether the party that exercised its reclamation rights is safe so long as it followed the state law reclamation procedures, or would they have to have followed the bankruptcy code's reclamation procedures? It seems like there's a majority that allow just under state law, but I cited a case here out of the Western District of Arkansas that found that the reclamation of property, because it was done under state law, but not in compliance with the bankruptcy code, it wasn't protected. So it's just something to be aware of. You know, we've got the federal bankruptcy code, which you would think would bring uniformity across the country, but each district is a little bit different with how they approach these. There's some black letter law, but that's why you really have to be careful depending on where you find yourself if bankruptcy is filed. One other limit on preferences is respect to payments on commodity contracts. So they can't be avoided as preferences, transfers to commodity brokers on account of commodity contracts. That's within a group of other similar types of contracts, security contracts, things like that. So those are some limits on preferences. Next, we will turn to statutory affirmative defenses to preferences. So Section 546C outlines a number of affirmative defenses to preferences. And with respect to these, the creditor will have the burden of proving the non-avoidability of a preference under one of these defenses versus the elements of the transfer the burden would lie with the party seeking to avoid them. And a principal aim of most of these affirmative defenses is to encourage creditors to continue doing business with debtors in their usual course, even as they're experiencing financial difficulties. Because the ultimate aim of a Chapter 11 reorganization is to have a company that's successful and able to continue doing business. It's better for the economy as a whole if these businesses can go through a bankruptcy and continue operating. folks stay employed, businesses that they do business with keep doing work with them. So that's kind of the aim of these affirmative defenses, is to encourage that process, is to keep things as ordinary as possible. So with that, we will turn to a few of the more popular affirmative defenses in this area. There is the contemporaneous exchange for new value, which is under section 547C1. So a transfer will not be avoidable to the extent it was intended by the parties to be a contemporaneous exchange of new value to the debtor, and in fact was substantially contemporaneous. In this context, the party's intent is what is paramount. If there is a small lag in time between the transfers from one to the other, that won't usually preclude a finding of it being substantially contemporaneous. I do have an example here of a situation in Eastern District of Arkansas where the parties had contracted for the delivery of wheat, like in an immediate exchange. Ultimately, the wheat was delivered July 21 and August 4, payment August 11. The court concluded, there's a small delay there, but it's substantially contemporaneous. That's what the parties intended, and that small lag wasn't enough to pull it out from that affirmative defense. So there's that one. And then we'll move on to the next, which is ordinary course. So under section 547C2, a transfer is not avoidable to the extent such transfer was in payment of debt incurred in the ordinary course of business or financial affairs of the parties, and it was made in the ordinary course of business or financial affairs of the parties, or according to ordinary business terms. As you might suspect, this defense, and really most of them, but this one is very fact intensive. It's going to look into all of the minutia of the transfers between the parties. So key considerations: the timing of payment. What was the timing of payment in the 90-day preference period? Invoice to payment. How long did it take on average? Versus a look back 2 to 3 years before that. And was there a change? Were payments made within 10 to 15 days of receipt of an invoice during that earlier period, and then it extended to 30 to 45 in the preference? You might be outside of the ordinary course. There's no set standard of how many days is ordinary and not. It really is going to depend on each particular case. And also the other things we look to in this instance: the manner in which payments are made, the length of time the parties were engaged in the dealing at issue. The recipient of a transfer isn't precluded from this defense, even if it was just one transaction with the debtor. So you would think, how do I establish an ordinary course defense if it was just one transaction? And so that's where you lean on the according to business terms. So you can look to industry-wide. How are payments on transactions like this dealt with by other parties in similar transactions? So you're not precluded from this defense if you only have one transaction in your history. Might be a tougher sell, but don't write it off. Other factors in this area: whether there were any unusual actions taken either by the debtor or a creditor to collect or pay the debt. Did the debtor take out a loan just to get this amount paid? Things like that, and taking it outside the ordinary course. Whether the creditor itself did anything to gain an advantage in light of a debtor's deteriorating financial situation, whether demanding, sending email after email saying, pay me, pay me, pay me, things like that can start weighing against ordinary course when you're getting outside of what would be the norm for your relationship. If that happened with every payment, maybe you've got it in the bag. So it's a very factual analysis. Turn to the next defense, which is subsequent new value under 547C4. So a transfer is not avoidable to the extent that the creditor gave new value to or for the benefit of the debtor, not secured by an otherwise unavoidable security interest, and on account of which the debtor did not make an otherwise unavoidable transfer to or for the benefit of the creditor. So breaking it down, it's essentially your preference exposure will be reduced by any new value given after the transfer is made. So let's say the debtor purchased goods from you on day 1. 10 days later, you're paid for those goods. So there's your preference risk. But after that, you gave them more goods. So those new goods would reduce the preference exposure. But if that new value that was given itself is an unavoidable transfer, you can't have it count against the new value. It ultimately ends up in kind of a netting of pluses and minuses, with, again, unfortunately, each court taking a slightly different approach, or well, there's groups of courts taking different approaches, with a small minority saying that that new value, if it was paid for, can't count in the netting. Though the majority of courts do allow that, and you just net them all out. There is a peculiar area where courts are wrestling with what happens when a post-bankruptcy filing payment is made on account of new value that was provided. So, and Monica is going to touch on these post-petition transfers, whether they're on account of critical vendor payments, where debtors get the authority to pay their critical vendors, or there's Section 503b9 claims for goods delivered in the 20 days leading up to a bankruptcy filing. Debtors will often get orders, and Monica's going to get into more of the nitty-gritty here, allowing them to pay those amounts. And there's a split growing in the courts of whether that payment would constitute an otherwise unavoidable transfer to or for the benefit of the creditor that then has to be essentially added back in. So your preference exposure goes back up. From my take on it, it looks like there's a growing shift to not counting those post-petition transfers, that there's a line drawn at the filing date, and that's how we review subsequent new value, but it's still a bit up in the air. It'll be interesting to see where that one goes. Math problems in bankruptcy. All right, so that's preference defenses. I think we have one more slide in that area. Thank you, Megan. A few others that are not necessarily statutory defenses, though arguably you could fit them in there. There's property of the estate. So a bankruptcy estate is comprised of all of a debtor's property. But if the transfer to the creditor was not the debtor's property to begin with, they might have been holding it, but holding it for another person, then that wouldn't be a preferential transfer. And we'll get into that shortly in the context of PACA and passive trust. So if it's trust assets, then they're protected essentially from being treated as preferential transfers. And I kind of just touched on these. And again, Monica will get into it more deeply, is critical vendors and Section 503 admin claims for goods delivered in the 20 days leading up to a bankruptcy, where a debtor has been given the authority to pay those creditors. The argument could be made that even if they received a preferential payment, because they'd end up getting paid pursuant to those orders, they're not ending up better situated than similar creditors. At least in the critical vendor context, where a debtor is given discretion to make those payments to critical vendors, it's harder for them to make this argument because the discretion sort of undercuts it a little bit. A debtor isn't usually required to pay any specific creditor. So the creditor will have a harder time saying, I would do just as fine. So those are some of the other defenses to preferences. Now, what can you do proactively? Get to our next slide. To protect yourself.
Jump back 1 second, Rachel, just to kind of add some practical advice. So the preference defenses that you described, and you did a wonderful job of describing them. And it's so weird in bankruptcy because these phrases just aren't intuitive. But oftentimes we have creditor clients that will receive a preference demand, and sometimes they just outright pay it. But the preference defenses that you described almost always will reduce preference exposure, and it can be substantial. So if you're one of our wonderful clients that receives a preference demand, reach out to Rachel or reach out to Megan. and have us look at your preference defenses and see how we can get your liability down, because we almost always can. And there's a great range of how much we can reduce, but those preference defenses can have real value.
Absolutely, Monica. Thank you. So before you get a demand, is there anything that you can do to protect yourself? Unfortunately, I'll just say at the outset here, there's a lot in this area of preferences that's outside of your control, because you don't know if a debtor is going to file a bankruptcy petition or when, and you can't necessarily control the timing of their payment. You would hope that they pay like clockwork, but that's not always the case. And unless you have a really close relationship, probably can't just pull the money from their account. So what can you do to protect yourself? Can obtain a security interest, such as a purchase money security interest. Those would essentially protect you by putting you above general unsecured creditors. If you have a security interest, that will generally ride through a bankruptcy. So you're in a better position by having it. And so that last element of did the preferential payment make you do better than you would have in a Chapter 7? The answer would be no, because you have a security interest. I had a client once that they sold high-end medical equipment in the hundreds of thousands of dollar ranges, and their terms and conditions allowed them to file a UCC and get a security interest in that equipment. Unfortunately for them, they did not file their UCCs and they remained unsecured creditors. And so when the hospital that they were supplying went into bankruptcy, they ended up being hit with a pretty substantial preference suit for all of this equipment that was paid in a totally higgledy-piggledy manner. Trying to establish ordinary course was practically impossible because there was 5 payments in a completely erratic manner for different pieces of equipment. The equipment, meanwhile, is sitting in hospitals. Those hospitals and all of their equipment were sold to third parties. So money's coming in on the backs of some of this equipment while my client's sitting there wishing they had filed their UCCs. File your UCC if you have the right to do so. This is my practice pointer on that one. Other things you can do, you can require prepayment. So rather than supplying goods and then get payment and then supply your goods, or contemporaneous exchange. Make sure that you're not having a huge delay between supplying and getting payment. You can require close monitoring so you have a sense of how is this client, customer, supplier doing. So you know whether there's something going on that you need to be aware of. You still want to maintain ordinary business terms to the extent you can. But it's just helpful to know if there's something potentially coming down the pike. You can obtain guarantees. The bankruptcy automatic stay protects only the debtor. So if you get a personal guarantee, whether from an officer, director, affiliate company, and they don't go into bankruptcy, you can still pursue your claims against that entity. So say money's clawed back, well, you're still owed it, go against your guarantee. Want to invoice as consistently as possible with the hope that you get paid on a consistent basis, and maintain good records. So if you're hit with a demand, you can get your records easily and account for your relationship. Which then brings us to the next step. What happens when you get a demand? Do not ignore it. And like Monica said, don't just pay it, because there's a good chance you've got defenses to at least a portion, if not all, of the demand for a preference avoidance. You want to gather your documents, invoices, proofs of delivery, statements of account, credit file, compile a payment history for 2 to 3 years before the bankruptcy filing that identifies invoices by payments, dates, amounts. Have that stuff ready to go. If you weren't provided a list of the subject transfers, ask for it. So the party making the demand, you can make a demand on them for the information that formed the basis of their demand. List of payments, evidence that they were actually received. Then you want to start considering all of your defenses. The ones we just discussed. Is it ordinary course, contemporaneous exchange? Does it hit monetary minimums? There's also considerations of the statute of limitations. The look back, or rather a claim for an avoidance claim has to be brought within 2 years of a bankruptcy filing. So if you look at the date the bankruptcy was filed and you receive your demand letter pretty close to that 2-year mark, it might change the dynamic and how you're dealing with the party that sent the demand. Are they about to start filing suit, or do you have more time to negotiate with them? Just things to keep in mind on a practical negotiating level. And of course, you would want to call a trusted bankruptcy advisor to give you guidance on all of this. It's unfortunately not a simple area, and it can be a particularly frustrating one because, again, we're dealing with payments that were made that were perfectly valid. You supplied goods and you were paid for them, and now you're being asked to give the money back. It's a totally weird bankruptcy situation that we have a lot of experience, unfortunately or fortunately, guiding folks through, reducing exposure, and getting you to the other side as hopefully efficiently as possible. So that is preferences. I'm not going to touch on just another small pre-bankruptcy area before turning it over to Monica. I'm going to return to this concept of property of the estate. Very broadly defined in the bankruptcy code, all legal and equitable interests of a debtor in property, wherever located, comprise its bankruptcy estate. But property of the estate does not include property that the debtor holds only legal title, but not an equitable interest. So trust funds held by a debtor for the benefit of a third party are not property of the estate. If a creditor can establish that funds received prior to a bankruptcy are not property of the estate, they can use that to defeat a preference claim and potentially seek turnover of those funds from the bankruptcy estate. So in this context today, it's particularly important. Go to the next slide. There's the Perishable Agricultural Commodities Act, which is, it was enacted in 1930 to regulate the marketing of perishable agricultural commodities in interstate and foreign commerce. So upon the delivery of perishable agricultural commodities to a purchaser, a trust arises by operation of law, a PACA trust. The res of that PACA trust consists of the delivered commodities, as well as inventories of food or other products derived from those commodities, and importantly, any receivables or proceeds arising from the sale of those commodities. Now, often the beneficiary of a trust would have the obligation of tracing funds and showing that those funds are part of my trust. But PACA puts the onus actually on the purchaser to establish that any assets are not subject to the PACA trust, because it's contemplated that commodities are sold, they're formed into some new food and then sold again, the funds come in, there's going to be a commingling there. So in that way, the supplier is given a bit of a leg up in this instance to protect itself and protect the PACA trust. PACA trust assets in a debtor's possession do not become property of the bankruptcy estate. So that's something key to remember there. If you delivered food and you met all of your PACA trust requirements, then those trust assets are not property of the debtor's bankruptcy estate. The specific PACA trust requirements are that you have to provide notice, whether on an invoice or specific language, or give notice of intent to preserve the trust benefits within 30 days from the payment date. The terms of payment cannot exceed 30 days, and the transaction must cross state lines or otherwise impact interstate commerce. So that's a PACA trust. And then we also have, on the next slide, Packers and Stockyards Act of 1921, which is a very similar statute in the context of livestock. So that's PASA, requires that packers who purchase livestock on a cash basis hold such livestock in trust for the unpaid cash sellers. And the livestock itself, it's similar to under PACA, where the trust is comprised of the meat or other products, accounts receivable, and proceeds derived therefrom. So it's not just the thing you sold, but the proceeds. To qualify for passive trust, the seller must not expressly extend credit to the buyer, and the purchaser's average annual purchases must exceed $500,000. So small purchasers are going to fall under that threshold, and they're not going to be subject to PASA trust, but larger purchasers will certainly be subject to this. And like with the PACA trust, if the conditions are satisfied, PASA trust assets in possession of a debtor do not become property of the bankruptcy estate. And there are two key benefits to this on the next slide, which is that preference defense. So if the funds used to make a preferential transfer were actually PACA trust or PASA trust assets, then no preference claim will lie, because it's not a transfer of the debtor's property. It was just the supplier's property being transferred back out of the trust to it. And the holders of PACA or PASA claims against a debtor, because the assets of the trust are not property of a debtor's bankruptcy estate, the beneficiaries of those trusts may be entitled to turnover of the funds from the bankruptcy estate on an expedited basis. A PACA trust or PASA trust beneficiary is entitled to claim trust property ahead of even creditors holding security interest in the property. So it really elevates the rights of the trust holders or the beneficiaries of the trust, apologies, above even secured creditors. So if you potentially have such a claim, you should pursue it in a bankruptcy. You can demand turnover of your trust assets, and there's ways of doing that. Again, you would want to reach out to a bankruptcy attorney to help you with that. That's certainly something that we could do, or even just discuss the next steps.
Well, thanks to Dr. Navarro and Mark and Kayla, I am now wondering if my bankruptcy code is made up of PFAS. I'm wondering that. But I think that would not matter, and it would not be false advertising, because as Rachel has just demonstrated, the bankruptcy code is not all natural. It's a little weird. So for those of you, and I know there are some participants, because we've worked with you, you are familiar with bankruptcy, and you will recognize that we are not discussing the bankruptcy code in chronological order. But we are going to jump around a little bit, and I tend not to give statutory references because I don't want to lose the audience, but we're going to do one here. We're going to talk briefly about Section 362 of the Bankruptcy Code, because it is something that creditors need to be aware of, and it is one of the most, if not absolutely the most fundamental debtor protections. So the automatic stay is an injunction. I like to describe it to clients as sort of like a giant iron curtain that comes crashing down at the start of a bankruptcy case. And the debtor is behind the iron curtain, and the rest of the world is outside of the iron curtain. So it's an injunction that goes into effect immediately at the same time that a bankruptcy case is filed. So when a debtor files its petition, automatic stay is absolute. It's automatic, goes into effect. It does not matter as a creditor whether you know about the bankruptcy case or not. It's completely irrelevant. You can have a customer that files bankruptcy. You can be unaware. You are subject to the automatic stay. The automatic stay prohibits almost anything that you would want to do, that you would dream up as a creditor, almost anything that you would want to do against a debtor and its property, including engaging in collection activities. So you cannot, as a creditor, send an email, make a phone call, send a default notice about your pre-bankruptcy claim. That would be prohibited. As a creditor, you cannot initiate or continue any litigation that you might have started before a bankruptcy case was filed. You can't recover or foreclose on collateral, and you can't modify or terminate contracts with the debtor. And we have teeny tiny little asterisks on the screen that I can't almost even see, but we are going to talk a little bit more about what it means to modify or terminate contracts towards the end of this discussion. And next slide right now, Megan, thanks. So actions taken in violation of the automatic stay are either void or voidable, depending on the jurisdiction in which the case is filed. So So as a creditor, if you decide to get cheeky and you violate the automatic stay, you are not going to get to enjoy the benefit or the consequences of your misdeeds, except in one very unfortunate way. Creditors that violate the automatic stay can be, in appropriate circumstances, subject to sanctions. And those sanctions can include punitive damages. And I know that some of you who are participating are aware of those cases. Those punitive damages can be rather substantial. So in terms of talking about the automatic stay and sort of coming down as a gigantic curtain, that curtain can also come up because the automatic stay can be lifted in appropriate circumstances. We're not going to talk about what the statutory basis is for lifting the stay. We don't have time to do that, but you should be aware of it. So creditors should be very careful before they take any kind of unilateral action in a bankruptcy case. You don't want to run afoul of the stay. And we like to say, consult with your trusted advisor before you do anything like that. Next slide, please, Megan. So as everybody has heard when we've been talking about preferences, the bankruptcy code is full of strange terminology. And section 365 is one of the best sections of the bankruptcy code to showcase that fact. So under the bankruptcy code, debtors are permitted to assume or reject their executory contracts and unexpired leases. This is just like the automatic stay. This is another fundamental debtor protection. Debtors love this provision of the bankruptcy code because it allows them to go through their contracts and review them and decide what they want to keep. So what does it mean for a debtor to assume an executory contract? Strange verb. It just means that a debtor has decided that it wants to keep its executory contract. It wants to continue to perform, and more to the point, it wants to receive the benefits of a particular contract because, for whatever reason, the contract is favorable to it. And sort of the best example here would be an undermarket lease with really favorable rent terms that a debtor would decide it wants to keep. Rejection, I think, is fairly intuitive, and it's just the opposite of what we described. It means that a debtor wants to be relieved of a particular executory contract because the contract, for whatever reason, is burdensome to it. The next slide, Megan. So you would think that the minds that came up with the phrase executory contract would have seen fit to define it. But unfortunately, the bankruptcy code does not contain a definition for what an executory contract is. It's kind of left to your imagination. I included the seminal description of executory contracts. It's known as the Countryman definition. I won't read it, but I will translate it. An executory contract really is just a contract under which there are substantial performance obligations that remain due on both sides. So both the debtor and the creditor have considerable things to do under the contract. And if they didn't do those things, they would be in breach. So next slide, please. So one thing that I did not put on my slide, but I think that I should talk about briefly. So depending on the chapter under which a bankruptcy case is filed, and depending on the type of executory contract or unexpired lease, there are different timeframes for a debtor to make decisions about its contracts. In the Chapter 11 context, generally speaking, a debtor will have until the time it confirms its bankruptcy plan to make this decision. And in large cases, that could be many, many months. And it could even be, a year and a half or 2 years, depending on how long the case is being administered. So again, this weird phrase, executory contracts, the weird definition, the phrase is very, very broad. If you have a written agreement with a debtor, most likely it's going to be an executory contract. Some examples, supply agreements, sale agreements, franchise agreements, IP agreements, which I didn't list. Again, if you have a written contract with a debtor, you need to think about whether it's executory or not. So the flip side, contracts are not executory if they have terminated or expired before a bankruptcy case has been filed. One little caveat to this, the contracts have to have terminated or expired of their own terms before a bankruptcy case is filed. We have had instances where creditors have wrongfully terminated executory contracts before a case filing, and the debtor has been able to resurrect or revive those contracts. Contracts also are not executory if they have been substantially performed, and contracts under which one party has nothing really remaining left to do other than make a money payment, those aren't executory either. So this is sort of the black letter statement of law under the bankruptcy code and what we counsel clients. But in the period before a debtor assumes or rejects an executory contract or an unexpired lease, the debtor generally, not always, is considered to be relieved of its performance obligations, but the non-debtor party must continue to perform. So again, asterisk, we'll discuss this a little bit later. Next slide, please. So nothing happens in a bankruptcy case, or at least it shouldn't, without the filing of a motion and court relief. So what does a debtor do that wants to assume or reject an executory contract or unexpired lease? Well, it has to file a motion and ask the court for permission to allow it to keep or reject certain contracts. A debtor's decision to assume or reject an executory contract or unexpired lease is subject to the business judgment standard. And this is just an incredibly deferential standard for a debtor. I don't think that I have ever seen a court override or substitute its decision in place of a debtor. So here's where it gets fun from a creditor's perspective. So far, we've talked about protections, the automatic stay, Section 365 with the executory contract provisions we're discussing, that are debtor protections and debtor friendly. This is going to be a creditor specific protection. If a debtor decides that it wants to assume an executory contract or unexpired lease, it must pay all pre and post bankruptcy obligations that it owes to a creditor, as well as provide assurances that it can perform going forward. So the payment of pre and post bankruptcy obligations is known as cure, which makes sense. The cure is a great thing. Assumption and cure is just huge for a creditor because it should result, at least in theory, in full payment to a creditor. So a great thing to happen for a creditor, assumption and cure. Next slide, please. So that being said, debtors can be sneaky, and creditors that don't monitor bankruptcy cases to watch and protect their cure rights can and will lose them. And this is one way in which it happens. As part of the motions that we have just described, or sometimes after the motions are filed, debtors will file exhibits containing, no joke, hundreds of pages of contracts with proposed cure amounts. In many of the larger cases in which we represent creditors, a debtor might have hundreds or even thousands of contracts. So it isn't unusual for us to be sifting through volumes of pages of contracts. And oftentimes debtors and creditors just flat out disagree with cure amounts. Even more often, debtors will list the cure amount as zero. So creditors that don't challenge listed cure amounts by filing an objection will be stuck with those amounts, as I noted, forever and ever and ever. So it is imperative that creditors that have written agreements monitor bankruptcy cases or retain counsel to do so that they can protect their rights. Next slide, please, Megan. So a quick aside about rejection. Rejection isn't nearly as exciting as assumption. When an executory contract or unexpired lease is rejected, it gives rise to, it constitutes a breach, which is considered to have occurred immediately before a bankruptcy case is filed, and it gives rise to an unsecured claim for rejection damages. And as weird as this sounds, it is not the same thing as termination of a contract. So don't be so sure that your contract has evaporated or gone away simply because it has been rejected. So next slide, please. So filing claims. Sadly, a lot of times our creditor clients don't think that it is worth filing a claim in bankruptcy cases. That is almost never the case. That is the way to protect your rights in a bankruptcy case. The deadline by which a proof of claim must be filed is sort of known in bankruptcy land as the bar date or just the claim deadline. Creditors, unless for some reason a debtor has the wrong address for you, should always receive notice of a deadline to file claims. The proof of claim deadline is like a statute of limitations, and you need to strictly observe it, except in rare circumstances. If you miss your deadline to file a claim, you are going to be out of luck as a creditor and you won't receive a distribution. Filing claims, especially for sophisticated lawyers, it's really easy. We do it all the time. It's a mainstay of what we do as bankruptcy lawyers. It's economical. Always happy to do it for you. You should almost always do it. Next slide, please. All right, we could have actually almost reversed the order of this discussion. Unsecured creditors or creditors that just don't hold a claim against a debtor that is based on collateral. Unsecured creditors comprise almost all of the creditors in any given bankruptcy case. As suppliers of goods or services here in the audience, you'll probably fall into this category almost always. General unsecured creditors are paid their pro rata share of distributions made to their class. And with rare exceptions, payment of pre-bankruptcy claims isn't authorized by the bankruptcy code, but we're going to quickly talk about two circumstances in which they are authorized. Next slide, please. So Rachel, I'm just jumping ahead a little bit, speeding up here. Rachel talked about Section 503b9 claims. If you are a supplier of goods, but not services, and you have provided goods that were received by a debtor within 20 days before the filing of a case, have your claim filed because you will receive full payment on that claim when you otherwise might receive pennies or nothing. So if you have a 503b9 claim, make sure that you file your claim properly and on time. Next slide. All right, the exception, critical vendor claims. Rachel touched on this briefly. Debtors frequently seek court approval to pay the pre-bankruptcy claims of so-called critical vendors. But what is a critical vendor? It is a vendor that provides something that is, well, critical. It's essential goods or services that are needed to preserve and maximize the value of a debtor's operations and its ability to reorganize or liquidate or whatever it's trying to accomplish in bankruptcy. Typically, I think of these as goods or services that a debtor can't source elsewhere easily and within a reasonable time frame. And sometimes a critical vendor is a single source supplier. Now, often, but not always, critical vendors don't have written agreements, executory contracts with a debtor. And that makes sense, right? Because if there isn't a written agreement, a debtor cannot compel performance and can't force a vendor to continue to supply. So if you are a vendor that falls into these categories, you have leverage and you should use it. Next slide, please. So again, with the motion concept, debtors usually file their motions at the start of their bankruptcy case as part of a larger package known as first day motions. There is some statutory basis in the bankruptcy code for critical vendor motions, but mostly they're supported by the doctrine of necessity. I won't read the quote, but I thought it was charming. The author described the doctrine as existing simply because it works. So for those of you who don't know, bankruptcy courts are courts of equity, and sometimes I like to think of them almost as courts of imagination. Those are the kind of courts where the doctrine of necessity works really, really well. So next slide, please. So the practical component for a critical vendor motion, it just makes sense. Often the total amount to be paid a critical vendor is so small compared to what a debtor is saving from not having to go out and source those essential goods or supplies. Keep in mind, if you are looking at a motion, you're not going to see your name as a creditor listed almost in every instance. You're not going to see an amount to be paid to you. And that's because debtors are seeking more broadly permission from the court to pay whomever they want to deem as critical. And you may see a debtor who says that they want to pay a certain amount on an individual or an aggregate basis, but not individually identified. So next slide, please. So as a condition to receiving the advantage of having your pre-bankruptcy claim paid, debtors will almost always require their critical vendors to agree to continue supplying goods or services during the duration of the bankruptcy case and on the most favorable terms that have been in place between a creditor and a debtor. So typically, debtors will look back and survey that historical relationship for a 1 or 2 year period and kind of cherry pick the most favorable terms. So this arrangement will be set forth in a short letter agreement, which will be legally binding on you as the critical vendor. If you are a critical vendor that agrees to provide goods or services and then changes its mind, you are going to find yourself having to return that particular payment. Vendor agreements come in various shapes and sizes. They can be modified. Sometimes they can be dispensed with completely. And that is going to depend on how essential and critical the product that you provide is. But you should not, as a creditor, automatically sign this agreement, kind of like the demand letter that we discussed. If you receive one, review it, reach out to your trusted advisor who can help you go through it. Next slide, please. All right, we've included a sample critical vendor agreement from the Vuray case, a recent case out of Delaware. We won't go into it, but I wanted everyone to see it just in case you are a creditor that receives something like this, you will know what it is. All right, so I actually don't think we're going to go over maybe a minute or two. So we've come to the asterisk part of our presentation. And Megan, can you actually advance one more slide? I think we're going to take these. All right, so if you are a vendor and you have been providing goods or services on credit to a party that files bankruptcy, do you need to continue to do that? Do you need to continue to supply goods or services on credit? Well, this is not the most satisfying answer, but I'm going to say that it depends. Generally, if you are a vendor selling goods or providing services on the basis of purchase orders and invoices only, you will have no obligation to continue to provide goods or services or to extend credit. Why do we say that? Because there is no executory contract between you and the debtor. Again, there are always going to be weird courts and weird exceptions. There are some cases that say that the purchase order standing alone or executory contracts. I don't think that's the right statement of the law. As noted above, the Bankruptcy Code requires you as a non-debtor party to an executory contract to continue to perform until the debtor decides what it wants to do with your contract. So if you are doing business under a sale or supply agreement or any other kind of executory contract, and you are providing that service on credit, you can expect that a debtor will want you to continue to do the same thing on the same terms. So next slide, please. We're going to go backwards. Sorry. All right. So if you find yourself in that position, rightfully, you're going to be concerned about extending additional credit and throwing good money after bad. You may hear from a debtor that you will have protections because you are providing things post-bankruptcy that give rise to an administrative expense claim. And in theory, that is true. However, many bankruptcy cases are administratively insolvent. So if you as a vendor provide goods or services post-bankruptcy, you need to do that knowing fully well that you may not be fully paid. In these circumstances, vendors that want to push back may be able to assert certain protections under Article 2 of the UCC. And these provisions can provide independent or complementary bases for filing various motions in bankruptcy court and seeking relief. Again, don't do anything unilaterally. Reach out to your trusted bankruptcy advisor. You do not want to violate the automatic stay or run afoul of other provisions of the Bankruptcy Code. But sometimes there are things that you can do to rock the boat a little bit, as long as you do it, being fully informed and being consulted in consultation with your lawyer. So I think we only ran over a few minutes. I'm sorry that we had to accelerate there. Thank you for attending. If you are getting CLE credit like all of us are, return your completed sign-in to the email address on the screen. And then Dorsey will send out certificates after that fact. If you have any questions, please, we invite you to follow up with us or anyone else on your Dorsey team. And materials and sign-in are available for download at the email address on the screen. Thank you very much. I hope everyone has a great day.